Assalamualaikum warahmatullahi wabarakatuh. My name is Fatimah Az-Zahra binti Muhammad Nizam, and I will be presenting on the case of Zamri bin Idrus and Zaiti Ahta binti Omar. So this case is about the application for polygamy. So in this case, the plaintiff and defendant were married in 1998 and have 4 children. The plaintiff applied permission to practice polygamy under Section 23 Clause 4 of the Islamic Family Law State of Selangor Enactment 2003. The plaintiff argued in support of his application that the marriage was a must and a necessity because the parties agreed to care for the future wife, which is the third party. And he also claimed that it is to provide an opportunity to ease her burden. And the plaintiff claimed that he was able in terms of financial liability and could act fairly. And last but not least, he also claimed that the proposed marriage will not harm the defendant's reputation because all of her needs were and would be met. So the issue in this case is that whether the plaintiff can fulfill the criteria under Section 23 Clause 5 of the Islamic Family Law State of Selangor Enactment 2003. So in deciding whether the plaintiff can apply for polygamous marriage, the court referred to the 4 conditions provided under the section. Firstly, the proposed marriage is a must and a necessity. So in this case, the court found that the defendant could still provide and meet the plaintiff's physical needs and his needs for intimacy. And the defendant also did not consent to easing the third-party burdens. And secondly, whether the plaintiff was able to provide maintenance for the current wife and the future wife. In this case, the court found out that the defendant denied the plaintiff financial ability to engage in polygamy and stated that throughout the period of marriage, he had failed to provide sufficient and adequate maintenance for her and also the children. She also asserted that she had to pay for the daily necessities as well as bear paying for their family needs, including making payments for the house, vehicle, children's schooling, as well as the cost for food and drink. And for the third condition is that whether the plaintiff could provide fair treatment to the current wife and the future wife. So in this case, the plaintiff had failed to prove that he was able to provide fair treatment if he was allowed to practice polygamy. So the plaintiff ground to support this condition also was dismissed. Moving on to the last condition that the plaintiff must fulfill is that whether the polygamous marriage will bring harm, darar syar'i, to the current wife. Okay, so what it means by darar syar'i is harm, according to what is normally recognized by Islamic law, that affect the wife in respect of her religion, life, body, mind, or property. And according to the Sunnah source, the term darar syar'i is originated from a tradition of the Prophet ﷺ, which stated la darar wa la dirar, which means harmful or revengeful act towards the other, whereby it may benefit the actor but harms other, or it may not even bring any benefit to either parties at all. So as such, it has been prohibited. So in this case, the defendant claimed that the proposed marriage interrupt the children's education and caused her psychological distress. And they frequently argue when the subject of polygamy came up. And the defendant also had to face embarrassment as the plaintiff publicly announced his intention to practice polygamy and openly display his relationship with the third party. So, as the plaintiff failed to fulfill all these conditions, the court dismissed his claim to practice polygamy. So, what we can learn from this case is that this case shows that applying for polygamous marriage is not simple. All of the requirements outlined in the Islamic Family Law Act must be met by the husband. And why? Because the goal is to ensure that the polygamy is practiced fairly. Furthermore, as indicated in the previous case, the Sharia court can only grant permission if the husband meets the requirement so that the woman receives justice. So I think that's all from me. Thank you.
My name is Nu'aisha Masra binti Hussein. My metric number is 120247, and inshallah today we will discuss about the case of Muhammad Shawar Jaikumar bin Abdullah and Rosita binti Mat Isel. This case was under the topic of betrothal, and it's under the jurisdictions of Syariah Subordinate Court Taiping and under the principle of Section 15 of Islamic Family Law Para Enactment 2004. And in this case, as we know, one of the requirements towards the betrothal agreement that the betrothal agreement itself must according to Hukum Syara. So, in this case, the plaintiff and the defendant had become a close friends and subsequently stayed together as a husband and wife, although they had not married yet at that moment. So, later, they planned to marry and the plaintiff converted to Islam as the request by the defendants. And with the payment of 600 ringgit, they purchased a forged marriage certificate and stayed as husband and wife. And also at that time, they did not marry yet. During the relationship, defendant requests an amount of 3,000 ringgit as engagement ring, and as the defendant had at that time has no money, so they agreed to give the money towards the defendant by paying 300 monthly. Then the plaintiff discovered that the defendant had cheated on him, so the plaintiff filed an application after the defendant refused to marry him. So, by claiming the damages for breach of the marriage of the contract. So, the issue is whether the plaintiff, which is Muhammad Syawal Jayakumar, entitled to get the compensation from the defendant for the breach of the promise. So, in this case, the court held that they had not entered into the betrothal agreement as there was no any engagement ceremony, and it has been held and there was no any representative of the party and that had met to discuss and approve their engagement in accordance with Hukum Syara. So, as there was no proof about any engagement ceremony which according to Hukum Syara, so the court held that there was no betrothal agreement between them. So the issue about the payment of 300 ringgit per month that requested by the defendant as an engagement gift could not be considered as engagement gift, as it was more towards the maintenance of the payment or the plaintiff contributions toward the defendant, as they say together, and by the proof of the copy of the forged marriage certificate itself, it showed that they had lived as husband and wife and not be betrothed. So, in this case, as there was the plaintiff, which is Muhammad Syawal Jayakumar, did not entitled to get any compensation from defendant for the breach of promise to marry, as at the first place the betrothal agreement between them has not entered between the party itself, as it not accordance to the Hukum Syara. That's all for me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Ifa Radwa binti Kamaruzaman, and my metric number is 1202140. So I will be presenting the case under the topic of wife disentitlement of maintenance. So in the case of Rogayah binti Yaqub and Ahmad Zainuddin bin Yaqub, the facts in this case that the parties, who is the plaintiff, which is the wife, and the husband, which is the defendant, were married and blessed with 3 children. So they stayed together in Negeri Sembilan, and after that they moved to Kelantan due to the defendant's business purpose. So after that, their relationship deteriorates, and during that period, the plaintiff frequently visited the National Heart Institute in Kuala Lumpur due to her heart disease. So because of this, the plaintiff and their children, with the defendant's permission, moved to plaintiff's hometown, which is Kuala Pilah. So the defendant, after that, he refused to move together with the plaintiff due to his business, and the plaintiff also refused to return to Kelantan when requested by the defendant due to her medical needs and trouble managing the household if she is not with her parents in her hometown. So, during that period, the defendant rarely visited them and neglected his duties to give maintenance. So, due to this reason, the plaintiff applied for fasakh divorce. So, the issue arises in this case is whether the plaintiff will still be entitled to maintenance despite her refusal to return and stay with the defendant. In this case, the court held that under Section 59 of Islamic Family Law Act, clearly stated that nushuz occurs when wife intentionally refuses to abide by lawful wishes of the husband. However, if she has valid reason according to hukum syara, then it is not nushuz. And in this case, it is clearly shown that the plaintiff has a valid reason for her refusal, which is due to her heart condition and in need for continuous treatment at the National Heart Institute, Kuala Lumpur. So that's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Ila Sharifah binti Sudiman and my metric number is 1202146. As for now, I'll be presenting the case of Ida Hidayati binti Taufik and Ahmad Shukri bin Qasim under the topic of maintenance and mut'ah. As for the facts of the case, the plaintiff was married to the defendant, who is known as a pilot attached to Malaysian Airline System, MAS, in 1993. Their marriage came to an end with a divorce in 1998 via a court order. From their marriage, they had a daughter who is now 7 years old. The plaintiff herein was claiming for mut'ah and maintenance during iddah, that is in sum of 144,000 ringgit and 6,370 ringgit 40 cents respectively. The defendant is currently remarried to another lady who was said to have been the cause of their divorce. Meanwhile, the plaintiff was still a single mother. In this case, it consists of 3 issues, which are the first one, whether the court has the jurisdiction over the plaintiff's claim. Second, whether the plaintiff has the right to claim for mut'ah, and if so, the appropriate amount. Third, whether the plaintiff has the right to claim maintenance during iddah, and if so, the appropriate amount. Now we move forward to the judgment of the case. As for the first issue, the court held that the said court had jurisdiction to hear, try and decide on the case based on the following provisions, which are Section 4 of the Islamic Family Law Enactment State of Selangor 1984, since the plaintiff's residence address was within the jurisdiction of the court, including with the Section 42 Clause 2B and Section 43 of Administration of Islamic Law Enactment 1989, and Section 56 that provides for mut'ah, and 59 that provides for maintenance of wife of Islamic Family Law Enactment, State of Selangor 1984. Aside from that, for the second issue, the judge agreed that the plaintiff have the right to claim for mut'ah payment from the defendant upon their divorce. Hence, it is compulsory for the defendant to give mut'ah to the plaintiff. Thus, the plaintiff was entitled to mut'ah in the amount of 48,000 ringgit only. Now, as for the third issue, the scholars agreed that the husband was obliged to pay for his wife's living, as his wife was in her iddah raj'i, because it is considered that she's still his wife until the expiration of her iddah, depending on the state of the wife divorced. So, the defendant is obliged to pay nafkah iddah for 3 months and 10 days, or 3 times the period of menstrual cycle of the plaintiff. Nafkah iddah of 4,100 ringgit only includes the cost of food and drink, while the cost of travel to work is unreasonable to claim by the plaintiff. Lastly, we move forward to the commentary part. In my opinion, I agree with the court decision to entitle those claims to the plaintiff that is in accordance with the Sharia laws. Hence, it can be seen here that the judgment in this case is fair to the both sides, as the specified amount was calculated by the virtue of the factors in determining the appropriate rate of mut'ah. I guess that's all for me. Thank you.